Are AI platforms allowed to train their algorithms on copyrighted books without the author's permission? This was the heart of the judgment in Bartz versus Anthropic, and that's what we will be discussing in today's episode. Imagine you write a book. You put your blood, sweat, and tears into it. Some company gets a hold of the book and trains their AI on the book without your permission. Now, the AI system can provide extracts, summaries of this book. Is that fair to you as the author of the book? As you will see, the ruling in this case could completely change how AI algorithms are trained in the future and what amounts to fair use as far as IP law is concerned. Hi and welcome back to the channel and to the series that I like to call the Case Files. In this series, we look at judgments from all over the world to understand how its judgment can impact our society. So let's discuss Bartz versus Anthropic. The case was filed by a group of authors including Andrea Bartz, Charles Graeber, and Kirk Wallace Johnson, among others. They filed a lawsuit against Anthropic, a company behind the Claude AI model. Bartz and others complained that Anthropic used their books, which are completely copyrighted works without their permission, to train their Claude AI model. Now here's what's interesting. Anthropic didn't just use publicly available data. According to the facts, Anthropic trained their model on two massive pools of text. Number one, lawfully acquired books. This is where Anthropic bought physical copies of the books and scanned them into digital form. Number two, pirated digital copies, where Anthropic used millions of ebooks downloaded from websites which provided pirated copies of those books. Now, for the uninitiated in you, a pirated copy of a book basically means an illegal copy of the book. These could be PDF, EPUB, or text file versions of books which are uploaded onto websites or file sharing platforms where people can download them without the author's permission. Anyway, back to the facts. Now, all these books, which are sourced from these two methods, formed what Anthropic called the central library on which their Claude AI model was trained. The authors claimed that the library was basically a vault of stolen works, whereas Anthropic claimed that it was a transformative use, therefore it fell within the definition of fair use. A quick explainer here. Two legal ideas keep coming up in this case over and over. That is, fair use and transformative use. Fair use is the term used for defenses available against copyright violation. Fair use lets people use copyrighted material without permission in certain situations like education, criticism, news reporting, or research, as long as the new use adds something new or serves a different purpose. So a big part of fair use is this idea that is called transformative use. This is when you change the original work in a meaningful way, therefore you're not just copying it, but you are transforming it. So if you quote a novel in a book review or sample a song in a parody, that can be transformative, meaning it gives the original work a new meaning, so it might be allowed under the fair use exception. Now in this case, the AI system read the book in order to understand the patterns in the book rather than to republish it. So is it a transformative use? Was it fair use? That's what the judges had to decide. So the case was decided by Judge William Alsop in the Northern District of California. The judgment wasn't black and white. The judge split the ruling into two parts. Part 1, with regard to the use of legally purchased books by Anthropic in their training data, the judge held that it fell within the definition of fair use. The judge said that training an AI model is an exceedingly transformative use. He highlighted that the AI platform was not copying or republishing the text. It was simply learning new statistical patterns to generate new outputs. He applied the 4 factors that are looked at when deciding whether something is fair use: purpose, nature, amount, and market impact. They found that 3 of them favored Anthropic. Basically, the judge was saying that the use of lawfully purchased books in the training data did not impact the sales of those books for the authors. Because the AI didn't republish the book, that means you can't go on Claude AI and ask to read this book completely for free. Instead, the judge believed that the AI was using the original material in a new and meaningful manner. So the summary judgment on this part was that the using of legally purchased books in training data, as long as you didn't redistribute it, amounted to fair use. Part 2, with regard to the use of pirated books in their training data, the judge drew a hard line. He ruled that Anthropic's use of these pirated copies was not protected under the fair use exception. He held that fair use doesn't cover unlawful acquisitions. If you obtain the data illegally, you don't get to later call it transformative use. So the second part, along with the potential damages, was sent to trial. Finally, in September 2025, Anthropic reached a $1.5 billion settlement with the authors, which is considered one of the largest copyright settlements of the AI age. The judgment could have monumental consequences going forward. This judgment was one of the first to say that the data used for AI training qualifies within the definition of fair use, at least within certain conditions. For AI companies, this is a green light, but only if their data comes from lawful sources. For authors and publishers, it's both a win and a warning. Using pirated copies of the books are illegal and the authors are protected. But using lawfully obtained copies for training is fair use. This judgment, however, has been criticized. Critics say it stretches the fair use exception too far by letting AI companies use entire books without paying authors. It undermines the author's rights and could hurt potential licensing markets where authors could license their books to AI platforms. And it didn't clearly define how much transformation is enough to qualify as transformative use under the fair use exception. The ripple effect of this judgment will now be felt by other AI companies like OpenAI, Meta, and Google. And also, lawmakers will have to start thinking about reforms to copyright law in this AI age. So to conclude, AI is here to stay. But an important conversation is arising on the ethical training of these algorithms. In this conversation, we need to decide whether AI platforms should be allowed to train on copyrighted works without the permission of the authors. Bartz versus Anthropic believes that if the books are legally purchased, then using that book to train the AI platform comes within the definition of fair use. So what do you think? Do you think AI companies should be allowed to train on copyrighted material without the permission of authors? Let me know in the comments below. And as always, if you found this useful, please do consider liking the video and subscribing to the channel. You can also check out other episodes in this series by clicking on the link which is on the screen now. I'll see you in the next one. Take care. Bye.